everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. Now, some of you may have heard that London is the divorce capital of the world. And this is a reputation that isn't just gossip. In practice, if we look at statistics, the English courts regularly handle a striking number of cross-border, high-value divorce claims. Actually, about half of the very high-value divorce cases heard in England involve international parties. There have been some recent high-profile rulings, including a Court of Appeal decision allowing a multi-million-pound claim to proceed in London, which has kept the issue firmly in the headlines. So in this episode, we're going to unpack what makes London such a magnet for divorce cases and whether this title is earned, exaggerated, or changing. So to discuss this topic, I've invited Agata Osinska, and she is a family solicitor and mediator at the International Family Law Group. Agata has a particular interest in cross-border cases, and she handles a wide variety of financial matters, including pre- and post-marital agreements, cohabitation agreements, financial proceedings following a divorce, asset freezing and tracing, financial provisions for children, and proceedings after a foreign divorce. Agata, thank you so much for joining us today.
Thank you for inviting me, Chloe.
So maybe we dive right into the matter. What is it about London and England as a jurisdiction that makes it so attractive to people to try and divorce in this country?
I think it's just that common knowledge, and we really had that label for a while now that our judges are much more favorable to the financially weaker party, and in most cases that's the wife.
Yeah.
And I think compared to other jurisdictions, that tends to not be the case. And because the judges here have such a discretion to consider all the circumstances in the case and to take into account the variety of factors, I think the financially weaker parties especially hope that they will have a better result than in other places around the world.
Yeah, and I've seen that a lot actually, especially with European countries that have, matrimonial regimes that are very clear about how assets get split. And sometimes it's not the person's advantage. And in England, they have more of a roll of the dice, right? There's more opportunity for a different outcome.
I think we just look more at facts and what exactly happened in the marriage and how the marriage looked like, what was the standard of living within that marriage, what kind of life they had together,
Yeah.
and take it from there. Whereas in other jurisdictions, it seems to be, like you say, the matrimonial regime in France and in many other countries.
Mhm.
And same with the pre and post nuptial agreements. We have those, and they're more and more important in this jurisdiction, but they're still not binding
Yeah.
and still not as common. Whereas in some of the European jurisdictions, it's kind of like like an automatic step. When you become
Yeah.
married, you enter into that kind of regime, and you have a bit more clarity in terms of what might happen if there is a divorce. But we all know life doesn't work like that. And as much clarity as you might want to have, that might not always be the end result.
Yeah. And so in England, I mean, there's an advantage and a disadvantage. You don't know what outcome you're going to get. There's a lot less certainty than in other countries, but there is that opportunity for the judge to look at the entire picture and to try and come up with an agreement that is fair, rather than, abiding to whatever terms have been agreed at the start of the marriage.
Well, exactly. I think the fairness is the thing on top of the judge's agenda. But equally, I think it's very tricky for us lawyers. It's tricky sometimes to advise because of the wide discretion that the judges have.
Yeah.
So it's very much roll of a dice sometimes, especially when you have very conflicting arguments on both sides, and you're like, well, where will the judge sit in all of this? So.
Yes. Yeah, it's harder to predict for sure. So there's certain features though in the English system that make it attractive as well. Things like financial disclosure, stuff like that. Could you talk us through those?
Of course. I think financial disclosure is a big one, especially compared to some other jurisdictions where um, there are no such provisions for full financial disclosure.
Yeah.
So in England, when you get a divorce, you have a responsibility to disclose all your finances, and that is all of them worldwide, not just in England. And that also includes trusts and companies, and things that you might have beneficial interest in. Whereas compared to some other jurisdictions, you don't need to disclose as many documents. We go through lengthy bank statements for all the accounts, normally for 12 months, but that can go back if needed. It can go back to, I had a case recently when I had 5 years of bank statements because there was a reason for it. You cannot just fish for whatever you want, but
Yes.
if there is a reason and a valid reason, the court can ask you to disclose more than 12 months of bank statements and other documents, whereas in other jurisdictions that's not always the case, and it's not always as straightforward to get that information out of the other person.
Yeah, and I think I see a lot of people opt for the English jurisdiction when they do have a choice because of that, especially if they are a bit less involved in the finances and they don't have visibility of what the matrimonial pot might look like. Having that security of knowing that there is a legally, enforced process to disclose assets, that actually their spouse could get in trouble for not disclosing items or lying on the forms. That's a really helpful piece of reassurance for people who feel that
Yeah.
otherwise they might just completely be fooled.
Yeah, and I think especially for women who often feel a lot more vulnerable in these situations, if they haven't had any kind of input into the finances, or they completely relied on the husband, not only in terms of providing financially, but just taking care of it. Sometimes in the initial meetings when the clients come to us, they will have no visibility at all in terms of what assets they do have, what assets they don't have, what liabilities there are. And it's quite striking. It's happening less and less, I think, and mainly because I think women are getting a bit more savvy, and we are talking about it more. I guess that's hopefully the information and the knowledge is kind of getting through to them. But at the same time, it doesn't only happen to women. Sometimes it's men. So we're being in this, growing and changing world where we need equality, and in order to achieve that equality, there needs to be financial disclosure, because without it, you're just guessing. It's a guessing game.
Exactly. And then you're discussing assets to divide, but you don't really know what they are for, in reality. So it
Yeah.
makes it all a lot more difficult. So it's true that for families where there is one of the two who doesn't have that visibility, England can be really an attractive destination for divorce. But I feel like we need to caveat that a little bit, just to make it clear that it's not a free for all, and anybody who wants can come and divorce in England. What would be the conditions, and under what kind of criteria would someone be able to file for divorce in England?
So it would depend if we're talking about a situation, because you've mentioned the recent changes and recent rulings. So if we are discussing financial provisions after foreign divorce, the requirements for those kind of claims are different. And obviously, in order to bring a kind of initial divorce proceedings here in England, the requirements are different for that. So if you want to start a divorce proceedings in England, then you need to have a proper connection with this country. So you need to meet the requirements in terms of jurisdiction. So either you need to be habitually resident here, or you need to be domiciled here. Those are the two main in a very short way. Those are the two main requirements. Either you or your husband need to have habitual residence or domicile. Now, for the kind of second pick at the cherry, if you got a divorce in another country and you feel like that wasn't fair and you got a really bad deal, there is something very odd in the UK system, in the English legal system, really, that allows you to make an application after a foreign divorce for for financial settlements. Now, the requirements for that are different. You need to show connection to England and Wales, and you need to show that you have a good case, essentially, that the court will not be wasting their time, because at the end of it, they don't want to spend months and months in proceedings on a case that will then be thrown away. So you cannot simply make an application straight away. You need to apply for permission first. So that's the
Yeah.
first hurdle. But once you're over that, and the court accepts that you have a good enough case and you have connection to the country, which mostly means living here,
Okay.
or having properties, having assets, substantive assets here, then yeah, you can ask the English court to look at your case again.
So is that what when we hear about high net worth cases coming to England, is it usually with that second scenario if they didn't like the initial ruling and they're trying to have it relooked at in England?
Yes, I think, well, we have plenty of international families living here in England, or having assets here already. So before they get a divorce in the first place, what they should have done is to seek advice from all the relevant jurisdictions that they might get a divorce in, and then really pick the one that is most favorable to them, right?
Yeah.
But that will obviously be different for the husband and the wife,
Yes.
having conflicting interests. Um, and it might not be only to do with who will get a better result. It might be to do with the timings, how quickly will they get divorce. It
Yeah.
might be to do with the costs. English
Yeah.
jurisdiction might be really good in terms of looking at the person's needs and being quite favorable to the financially weaker party. But we are also quite expensive as a jurisdiction in terms of running the litigation. So it's looking at all these things and also looking at the end of the day, enforceability. Because if
Yes.
you have assets all over the world, the fact that English court can make an order about those assets doesn't necessarily mean that the order will be enforced. And, how easy will it be to enforce it? Because the piece of paper might not be worth much if we're talking about a country that will just not do anything about it.
Yeah, I was going to come to that because it's all nice to come to England to get a ruling that you like better. But if your assets are abroad, you do need that foreign jurisdiction to enforce the ruling. So it's something for people to consider as well. It's not just that victory in court isn't necessarily the end of the game because you then need to put into motion everything that's in the order. And if you can't in practice, it's not worth the
Yeah.
paper it's.
So as a solicitor, I guess your role at the beginning of the case is to strategize it properly and think it through and think, right, can this be enforced if we get it? Or can we look more at the English assets that are easy for us to address and
Yeah,
kind of balance it out that way? So it's all those considerations that you need to take into account before you start a case. And
yeah,
in terms of the kind of second bite at the cherry, in terms of starting a case here after a foreign divorce, that's even more important because
yeah,
these cases are very expensive to run, and most of them will have foreign assets to deal with, and
yeah.
that's probably the reason why they're coming to England, because they weren't, like you said, they weren't happy with the result of the foreign court not addressing some of the assets. So the recent case of Potanina and Potanin, well, that been running for years and years now. So to give it a very short background story to it, this couple, Russian couple, they've been married in Russia for over 30 years. They got a divorce in Russia. They were a very, very wealthy family, probably one of the wealthiest families in Russia. Um, and the wife got, I believe it was around $40 million settlement at the end of the case.
Yeah.
And you would think, you're hearing the 40 million and you think, wow, that's amazing. That obviously gives you everything in the world that you might need. But if you live a life, on that level and that wealth, that might not mean much to you.
Yeah,
And that's,
yeah,
that's the reality of it. I think your standard of living might be different. It might just be something completely unimaginable to us normal human beings. So she wasn't happy with that result because the Russian jurisdiction during the divorce and the financial settlement, they didn't consider at all the husband's assets that were tied in trusts and companies. So they only considered assets that were, in his name or in their joint names. But not the trusts, not the companies, which obviously was most of his assets were kind of structured that way. I believe she said she only received what she believed to be 1% of the assets. So she then came to the UK. She obviously consulted lawyers and decided that she can have another go here in this jurisdiction. And at the beginning, she was refused permission. So she wasn't given permission because they've said that she didn't have enough of a connection, only coming here after divorce. But as the time kind of went by and all these proceedings were going, and she decided to appeal. And she did finally get a permission and was successful in her appeal. Now we are now at the stage of Court of Appeal decision, so it might still go to Supreme Court. It wouldn't surprise me if the husband decided to, give it another stab and hope for a best, because we are talking about billions of dollars here. My main worry would be how to enforce it, because it's all good and all good if she gets an order from the English court saying, really, this wasn't fair. She should have some of the trusts, some of the companies, because they've been married for a very long time. But it's in Russia. I don't know enough about the case, whether some of the assets are in different jurisdictions, but I believe most of them are in Russia. And with the current situation, how would that be enforced? With the connections that the husband has in Russia, I would be quite worried that all this work is for nothing.
Money.
So I'm quite, she might have got $40 million out of the Russian system. How much of that would be spent on legal fees to get to something, and then realize, well, is it enforceable? Will I actually get more? I don't know.
Yeah, in practice, exactly. Getting actually your hands on the money at the other end is another matter. So there's been a lot of conversations about this case potentially encouraging what we call divorce tourism, where people just relocate to the UK and then try to, as you say, have a second bite of the cherry. Do you think that that's a real concern, or is this just at this stage an isolated case, not enough to draw any conclusions?
I don't believe it's an isolated case. We see them quite a bit. Not in that volume. It's obviously quite a big case, but I think there is a worry, and there are also talks around changing the law and making some reforms in order to address that, but also the discretion that the judges have. There have been talks for years now over the fact that our system is so discretionary that perhaps there should be some limitations to it. But equally, I don't know how I feel about that, because the discretion allows the judge to be fair in the circumstances where other jurisdictions cannot be. So it's, there will always be that balance between limiting the discretion of the judges, but equally allowing them some flexibility so that they can address unfairness and they can address very specific circumstances of the cases and not just be very robotic about, this is how we divide it, this is how, because at the end of the day, it's family law. We're dealing with families, we're dealing with human beings, we're dealing with high emotions, and some of this should be taken into account, and it should be important. Yeah. So I think that's the tricky bit.
Yeah, I agree, and I think that's going to be, it's a difficult line to draw, and different jurisdictions have gone in different directions. But having maybe more clarity, at least, about when you have a chance of being able to divorce in England, or to try again in England. It might help with some couples not going about it and trying, to have a second iteration when they're not happy with the initial outcome. But for
Yeah,
those who are international couples, who are living in England and who have that option, to choose a jurisdiction, what would you give them as advice? What would be your advice in terms of making sure that they take those key points into consideration in deciding on the jurisdiction?
think there are a few points. I think it does depend on where the assets are based, and how, the enforceability is, in my eyes, key, because at the end of the day, you don't want to spend the money for nothing.
Yeah.
But equally, our jurisdiction looks a lot at the principles of sharing and needs, whereas other jurisdictions don't tend to do that anymore. I think we came a long way from, in last few years, we still had lifetime maintenance orders and all these things. That has changed, and I think the court has taken a view that with time we need to look at financial independence, and if someone has the earning capacity to meet their needs, we need to look at that a lot more. And I think that's fair. I think that's reasonable. And a lifetime maintenance order, which means that, for example, a husband would need to pay his ex-wife spousal maintenance until they both pass or he passes. I think that was, probably a bit too much in most cases. There are still
Mhm.
cases where a longer spousal maintenance is something that is appropriate,
Mhm.
because again, life is so different. People have so different circumstances that I think that discretion is important, and that
Yeah.
needs to stay. But if people are deciding which jurisdiction to pick, I think it very much depends on what they want out of their divorce, um, and whether what they want is achievable in this jurisdiction,
Yeah.
how much costs will be spent on this, and how easy it will be to enforce. Now, at the end of the day, I would say to every client, try to agree and try to not go to court. Obviously, that's not always possible. No matter how much we try to say, go and mediate, go and arbitrate, go and negotiate through solicitors, sometimes that's just it,
Yeah, it doesn't
and you
work for
have to go
everyone.
to court. But when you're looking at competing jurisdictions, I think you need to be very clear with what your priorities are and what you want to achieve, because you need to have um, you need to know your baseline of what you need to move forward to become independent, or to have your own life and be able to move to the next stage. Uh, and from that, we can properly advise, is this something that is achievable in this jurisdiction, or is there another jurisdiction that is better, for whatever reason, be it costs, be it enforceability, but just better for you and your circumstances and your family. That might mean, if there are children, they might want to move to a different jurisdiction. So perhaps for that reason, it would be better to get a divorce there and have everything kind of tied up quite neatly in terms of the child arrangements as well. So there's so many things to consider.
Yeah, they really are. It's not, I think a lot of people focus on the outcomes that they're likely to get in one jurisdiction or the other, but there's a lot of other factors. And there's one that we haven't mentioned, but I find comes up quite a bit, is the fact that in England and Wales we have no fault divorce. So you don't need to prove that the other person has done anything wrong or that you have done anything wrong. Whereas in some jurisdictions there's still fault-based divorce, where you will look at infidelity or abuse in those kind of cases. And for some people, that really matters. They want that recognition that the other person misbehaved, and so
Oh,
that could be a
completely.
differentiator as well.
Yeah, completely. I completely agree with that. I think when the change in our divorce law was introduced, I wondered whether completely getting rid of the blame is a good idea, because I think, especially for some don't get me wrong. I think the no fault divorce is a great thing when it works, but I do think that some, especially victims of domestic violence, um, they feel like they are being silenced,
Hmm.
and that is not recognized. We do have provisions within the financial proceedings to look at conduct and to how conduct is a factor in the
Yeah,
division of finances. But the threshold for that is extremely high.
yeah,
And in most cases, you running this argument with clients of whether it's worthwhile running, given how much more it will cost to run that argument, and what is the likelihood of it actually making a real difference in terms of
yeah,
what you will get at the end of it, and the stress and the pressure that will bring on. Because at the end
yeah,
of the day, if you run a conduct case, which means bringing behavior of the other party into the equation, um, that means that it's all out there. You will need to deal with these allegations, and you will need to prove them. And especially if there are children involved, you need to kind of have a look at the whole case and think, do I want this? Because this was, maybe it will make a financial difference, maybe, but at the end of the day, will it affect this family in a different way? And will it mean that there is no way they will be coming back from this, and the
yeah,
co-parenting will be just extremely difficult? But like you say, some people just need recognition and do things out of principles rather than the financial financial consequences to it. I think sometimes they just need to be acknowledged and need to feel heard.
yeah,
And it's extremely difficult advising those clients that we can do that, but it will cost you more and it might not make a difference in terms
yeah,
of the actual final decision. So I try to be as open as I can and as honest as I can with my clients at the beginning of the case, because I don't want them to feel like they are not being heard. But equally, I don't want them to regret those decisions and feel like, they've been went through hell going through these proceedings and picking up all the little pieces that they would rather forget
yeah.
from their marriage, and then feeling like actually, they said it, but have it made a difference?
Matter. Yeah,
Mm.
exactly. So that's another factor to take into consideration in those jurisdictional decisions.
For sure. And like you said, some of there are plenty of European jurisdictions that still have blame-based divorce, and there is a proper, announcement, judgment at the end of the case saying this is the person to blame, and because of this infidelity or because of this behavior, they will. That they will get less than what they would normally get, and that normally also follows consequences in terms of the children arrangements and things like that. Whereas in our jurisdiction, that is not as connected as people would want it to be.
Yeah,
And I think especially dealing with international families, when they have this view of how the divorce would look like and what is important and what isn't, you kind of need to really put them back at the starting line and just say, okay, we're starting from fresh. Whatever you know about the divorce process in your your the other jurisdiction, either the place that you're from or the place that you previously lived, that is nothing to do with the English
yeah,
jurisdiction. So this is the comparison. And that might mean that they will decide to go to the different jurisdiction because of
yeah.
those reasons, because of the emotional reasons and the baggage that brings to the case.
I agree. And the cultural match as well, between the person's
Yeah.
values and the justice system's values. This was a really, really helpful conversation. How can people reach you if they feel they need your help?
I can be emailed, phoned. So my email address is agata.osinska at iflg.uk.com. So it's a bit of an odd email. But I'm sure if they just look up online International Family Law Group, they will find us. And like you say, we deal with international family matters day in and day out, and they are a odd beast to deal with because of all the jurisdictions.
Absolutely. It's usually one of the biggest sticking point at the very start of a divorce and for an international divorce. Thanks
Yeah.
so much, Akata. Have a lovely day.
Thank you.